Eviction Lawyers for Tenants, California. Okay, let's dive right in. We're talking about something that honestly can feel pretty overwhelming if you're a renter in California. Eviction. It's just a lot.
It really is. A whole maze of laws, regulations.
Right. And today we're not just going to skim the surface.
No, definitely not. We're taking a focused look, really zeroing in on the key parts of California eviction law that, directly affect tenants.
Because let's face it, if you're renting here, maybe facing the possibility of eviction, you need clear info. You need to know your protections, your rights.
Exactly. And we're pulling from a really comprehensive guide, California Tenants' Rights. It's pretty thorough.
So the goal here is?
Well, the goal is basically to arm you, the tenant, with essential knowledge so you understand the process and, crucially, what your rights are in California.
Okay, it makes sense. So where do we even begin? The very start.
Yeah, let's start right at the foundation, your lease or rental agreement.
That piece of paper you sign.
That's the one. And rule number 1, highlighted right in the source material: never, ever sign something you don't fully get.
Don't just skim it.
No way. Take your time. Read every word. If something's fuzzy, ask questions. Get clarity before you sign. Seriously.
Okay. Now, the guide mentions a difference between leases and rental agreements. Can you break that down? What does it mean practically for a tenant?
Sure. So a lease is usually for a fixed time, like a year, typically.
It locks you in.
Right. Gives you security. Your rent, the main terms, they're set for that period. A rental agreement, though, that's usually month to month.
More flexible?
Yeah, offers flexibility if you might move soon. But, and this is a big but, it means the landlord can raise the rent or end the agreement with less notice.
How much notice are we talking?
Usually 30 days if you've been there under a year, 60 days if it's been a year or more, sometimes even 90 days in, like subsidized housing situations. And here's something tricky the source points out. Sometimes a document looks like a lease, maybe says 1 year, but has clauses allowing rent hikes or termination on shorter notice.
Oh, so it acts more like a month-to-month agreement then?
Kind of, yeah. It functions more like a written rental agreement in practice. You really have to read the details, not just the title.
Got it. Keep an eye out for that.
Absolutely. And this is where local laws kick in, too. Rent control, eviction control ordinances.
Right, those local rules.
Yeah. If your place is covered by those, some of the need for that fixed-term lease protection is less, because the local law already limits rent hikes and, why a landlord can evict.
But a lease could still be better.
It can be. The source notes that even with rent control, a lease might give you extra protection, say, against an owner wanting to move in, or maybe against certain rent increases the local law might technically allow.
Okay. What about those month-to-month deals? The flexibility sounds nice, but what's the catch?
Well, that flexibility, especially in a really competitive rental market, it might mean you're constantly facing potential rent increases. You're sort of paying a premium for that uncertainty.
So a lease acts like a shield.
Exactly. A shield against rapid changes. And the source also mentions breaking a lease if you have to leave early.
Yeah.
You're generally on the hook for rent till the lease ends. But the landlord has a legal duty to try reasonably hard to find a new tenant.
Oh, okay. So if they find someone,
then your obligation ends once that new person moves in and starts paying.
That's good to know. It sounds like landlords often lean towards written rental agreements, not leases. Why is that?
Mostly flexibility for them, managing the property. Unless local rent control is in play, they can raise the rent more easily and the tenancy faster if they have grounds. From a tenant's view, it often just doesn't offer that same security blanket a lease does.
Okay, this feels important. How do all these things fit together? State law, local law, your actual agreement.
Right. So, landlords and tenants can agree on a lot in a lease. But, and this is key, everything has to follow California state law and any local rules.
So the law trumps the lease.
If there's a conflict, yes. Any part of your agreement that goes against state or local law, it's invalid, can't be enforced.
Even if you signed it?
Even if you signed it. The source actually mentions landlords sometimes stick illegal clauses in there anyway, maybe hoping you won't know better.
Wow. So knowing the actual law is critical.
Absolutely vital. Your lease cannot legally take away rights guaranteed by law.
What about rules on using the property? Like no pets, no smoking.
Landlords can set rules like that. Pets, smoking, even stuff like where you put plants if it might damage floors, as long as the rules aren't discriminatory or retaliatory or breaking state law.
Any examples of rules they can't make?
Well, they can't stop you from running a licensed in-home daycare, for instance. But California law does specifically let them ban smoking entirely on the property.
Okay. What if things go sour and end up in court? Who pays the lawyers?
Generally, each side pays their own attorney fees in a standard lease dispute.
But there are exceptions.
Yes, big ones. If the lawsuit is about specific violations like discrimination or a retaliatory eviction or breaking rent control rules, then often state laws allow the winning side to get their attorney fees and court costs paid by the loser.
Good to know. The guide also says violating lease terms is grounds for termination. But there's a process, right? They can't just kick you out.
Oh, absolutely not. If you break a rule, they can't just change the locks. They have to follow specific legal steps. Notices, potentially going to court for an eviction. That's a whole process in itself.
Maybe something for another deep dive.
Could be. Now, about those really unfair lease clauses the source mentions, unconscionable ones.
Yeah, what's that about?
This is a huge protection. California Civil Code Section 1953 basically says you cannot waive certain fundamental rights in a lease. These are rights the law sees as so basic, you can't legally agree to give them up.
Like a bottom line.
Exactly. Your absolute bottom line protections, no matter what's written down. Especially important when you feel like you don't have much bargaining power.
Can you give an example or two? Of these rights, you can't sign away.
Sure. A key one is your right to hold the landlord responsible if their carelessness hurts you.
Okay. Landlord negligence.
Right. And another big one, the landlord's basic legal duty to provide and maintain a habitable place to live. Your lease just can't legally say you give those up.
That leads nicely into habitability then.
Yeah.
But first, what about liquidated damages? Sounds ominous.
Hey, it can sound that way. They're basically preset penalty fees in the lease, saying what you owe if you move out early.
Are those enforceable?
Courts look really closely at them. They're suspicious. If the fee seems way higher than the landlord's actual financial loss from you leaving early, a judge will likely say you don't have to pay it.
So it's maybe a scare tactic.
Often, yeah. Landlords might put them in hoping tenants won't know their rights and just pay. Don't be intimidated. But the source does point out fighting it in court takes effort. Best bet. Try to get that clause removed before you sign.
Right, proactive is better. Okay, let's shift gears to that other critical area. Habitability, making sure your place is actually livable.
Absolutely fundamental. California law has something called the implied warranty of habitability.
Implied meaning.
Meaning it exists automatically, by law, just because they're renting to you, whether it's written in the lease or not.
Even if you knew about problems when you moved in.
Even then, the landlord is legally promising the place is livable and will stay livable. It's not just a suggestion. It's a core legal duty. It recognizes a rental isn't just property. It's someone's home.
So what makes a place legally uninhabitable? Does it have to be falling down?
Not necessarily falling down, no. The legal definition is basically that it does not substantially comply with state or local housing codes, a significant failure to meet those standards.
What are some minimums? What has to be there and working?
Well, the state housing law is pretty clear. Every rental needs at least one working toilet, sink, and a bathtub or shower.
Okay.
And crucially, those have to be in a room that offers privacy, is properly ventilated, and kept safe and sanitary.
Any other examples?
Yeah, the health and safety kind lists more. Things like proper sanitation, overall good ventilation, no excessive dampness, weather protection, so no falling plaster, leaky roofs or walls, and no nuisances like mold, pests, illegal activity on the property.
What about the tenant's role? Can they be responsible if something's wrong?
Yes, the guide is clear on this. If a tenant causes a problem through carelessness or misuse, like, say, they deliberately break the only toilet the landlord can make them pay for the repair.
Okay, that makes sense.
Yeah, and they might deduct it from the security deposit. But, and this is really important, landlords cannot charge you for normal wear and tear.
Like the carpet just getting old from walking on it.
Exactly. That's not damage you caused. That's just the cost of doing business for the landlord.
The guide mentioned a landlord-tenant checklist. How does that fit in here?
Oh, that's a super useful tool. It helps document the condition of the place when you move in, maybe during inspections, and definitely when you move out.
Creates a record.
Precisely. It helps head off arguments later about what was already there versus what might be damaged versus what's just normal wear. It relates back to habitability and security deposits.
So if a place is genuinely uninhabitable, what can a tenant actually do? What are their options?
The source lays out a few key remedies. For serious issues, one option is rent withholding, but
Gotta be careful with that one.
extremely careful. You have to follow the legal procedures to the letter. Another is repair and deduct. You pay for necessary fixes yourself and subtract the cost from rent. Again, strict rules apply.
What else?
In really bad situations, if the place is truly unfit, you might have the right to just move out and end the lease legally.
Rock away.
Essentially, yes.
Yeah.
Be released from further obligations. And finally, you could potentially sue the landlord to force them to make repairs.
But withholding rent for, like, a minor dripping faucet is a bad idea.
Definitely a bad idea. The guide warns against it. Improperly withholding rent for minor stuff could get you evicted for non-payment. Save these big remedies for major problems.
Okay, let's talk privacy. When can the landlord actually come into your place? This feels like a big one for renters.
It is, absolutely. When you rent, you get exclusive possession. The law talks about your right to quiet enjoyment. The landlord has to protect that, even from themselves entering too often or without reason.
So they can't just pop in whenever.
Generally, no, unless it's a real emergency fire, flood, something like that.
Okay.
Otherwise, they usually need to give you reasonable notice.
And reasonable usually means?
Well, it's not perfectly defined everywhere, but 24 hours written notice is often considered the standard. And the source notes, tenants can actually formally request that 24-hour written notice, citing the Civil Code.
So you can insist on getting it in writing.
You can request it, yes, citing Civil Code Section 1954.
What are the valid reasons for them to enter, even with notice?
The law allows entry for things like necessary or agreed upon repairs, to show the unit to potential new tenants, but usually only near the end of your lease.
Like the last month or two.
Right. And also to show it to potential buyers if the property is being sold.
But there are still limits.
Yes. They can't just come in to snoop around or do a general inspection unless you've specifically agreed to that. And they can't give, say, a prospective buyer a key for unlimited access. It has to be controlled.
Are there special rules if they're selling the place?
Yeah, there are. If the landlord gave you written notice within the last 120 days, 4 months, that they plan to sell and might contact you for showings,
Okay.
then oral notice phone or in person 24 hours beforehand is considered reasonable for a showing. But importantly, they still have to leave a written note inside saying they were there.
What if a tenant thinks the landlord is coming in improperly? What can they do?
It's a bit tricky, honestly. The source points out a risk. If you don't have a lease or you're not in a city with just cause eviction rules, pushing back too hard, even if you're right, could unfortunately result in the landlord just giving you a notice to leave.
Retaliation, basically.
Potentially, yeah. And even if you could eventually prove it was a legal retaliation, you might still be forced out in the meantime. It's a tough spot.
What about police? Can a landlord just call the cops to come into your apartment?
Not usually, no. Police generally need a warrant signed by a judge.
Unless
Unless there's a genuine emergency, like preventing serious injury or a crime, catching a fleeing felon, stopping evidence destruction, standard exceptions.
Okay.
But importantly, the source stresses landlords cannot use the police just to harass tenants or break up tenant organizing meetings. And they can't evict you just for hosting meetings about tenant rights, even if you happen to be behind on rent.
That's a really important protection for tenant organizing.
Absolutely.
Wow. Okay. This has been incredibly helpful, really clarifying some crucial areas of California tenant law, especially around eviction possibilities. Any final takeaways for listeners?
Yeah, just to quickly hit the highlights again. Really understand your lease before signing. Know that your landlord has that fundamental duty, the implied warranty of habitability, to provide and maintain a livable home.
And your privacy.
And your right to privacy. Landlords can't just enter whenever they please. There are rules, notice requirements. Know them.
Absolutely. This deep dive really sheds light on those foundational pieces.
And for everyone listening, maybe take a moment later, pull out your own lease. Think about your current place. After hearing this, do you feel more informed? Do you feel protected? Just something to reflect on.
And if you are a tenant, maybe in Orange County, Riverside, San Diego, or Los Angeles, and you're actually facing an eviction notice or serious issues with your landlord, it's good to know there are specialized resources.
Right.
MartinezLawCenter.com is one place to look. They specifically focus on representing tenants, not landlords, in eviction defense in those counties. That kind of specialized help can make a huge difference.
Having someone on your side who only represents tenants, Yeah, that's valuable expertise when you're up against eviction.
Definitely.
And, looking ahead, there's so much more we could unpack. Specific eviction procedures, how to respond to different notices, other rights.
Lots more ground to cover, potentially.
For sure. But hopefully, this deep dive today has given everyone a much clearer, more solid understanding of some core tenant rights here in California.
Call now 714-442-9741. Thank you.